Okay. Hello, everybody. We'll wait for 1 minute and then we will kick off the webinar. Thank you very much for being early with us. All right, I have 5 too, so I think I'm actually supposed to start. Welcome everybody. Welcome to another group therapy session, I'd say. I'm Sophie Stella-Bourdillon. I am co-director of the Brussels Privacy Hub, and I happen to be in a very good company this evening. I'll tell you more in just a few minutes. I just wanted to do a short introduction to the topic. Privacy and data protection law washing seems to be coming from all directions these days, even from sources that on paper ought to appreciate the elegance of principle-based lawmaking, I would argue. What is principle-based lawmaking? It's a kind of effortless elegance, much like what Italian style is famous for. Not to be confused with simplicity by design, as they say. I wanted to start with an anecdote because once upon a time I was an apprentice lawyer trying to produce some privacy and data protection language for some privacy notices that were supposed to describe processing activities triggered by a website and a few other marketing techniques. So I was trying to work on that draft, trying to make it as concise as possible. And I thought I was close to completion when I had a second thought. And my second thought was, why not try to anticipate compliance with other privacy laws, such as CCPA turned into CPRA? And so I tried that, and then corporate due diligence meant that I had my copy reviewed by some external lawyers. And they scraped several parts of my work because I was not using the very precise terminology that we have in the law or in the statute to describe data points and purposes. And I got a little bit annoyed. But when I received it, I said, okay, I will let them rewrite the policy, which they did for a not so small fee. But when I received it, I got even more confused because now I could not really understand anymore what is it I was describing. Two types of terminology for the same data flows with completely different data categories. So we ended up having 2 privacy notices for the price of 1 or 3 maybe to describe different terms and with different terms the same data flows. Of course, that was just the beginning because other US state laws were about to be enacted, and each time with a slightly different language. So yes, I have to acknowledge that I've hated my job at times, but was it because the law, or better the GDPR as it was, and still is, was too complex? When we talk about complexity, we have, I think, to be extremely precise. Which complexity are we really talking about? There's lots of different meanings that could be advanced here, but one thing is sure, when we talk about, for example, row paths and data mapping, the complexity is not so much coming from the law itself, but maybe from the opacity of the data flows and the way technology is being built. So in an attempt to try to eliminate misunderstandings, I thought it was very important to come together and have engaged into comparative law overview and interpretation to understand how GDPR actually compares with other privacy and data protection laws. And for that, I have the great pleasure to welcome 3 fantastic speakers this evening. Nadya Purtova, who is professor at Utrecht University. She's been working in that space for many years, and in particular looking at the scope and remit of data protection law. She's known for the concepts of and in particular the paper of Law of Everything. So she's very well placed to look at GDPR in the age of simplification. Karen McCullagh, she's associate professor in the UK, University of East Anglia. She's also a very rich background in the data protection space, and has been working in collaboration also with lots of computer scientists in different places. So she will bring insight into the UK perspective. And finally, last but not least, Bryce Newell, who is associate professor at Oregon University. Thank you so much, Bryce Newell, for waking up early and being with us this evening to try to give us an overview of what US law is about and the different bits and pieces that are emerging from the different states. I thought actually I would start with Bryce, just so that we get a taste of what's happening in the US. Bryce, can you, just to start the discussion, can you give us an overview of where we are at with US privacy laws today, maybe both at the state and federal level?
Yeah, absolutely. And thank you very much for having me. It's great to be here and to join all of you. I will have to say I feel a bit like you did, Sophie, with thinking about sort of the complexity of this, and also now part of the complexity in the US is not necessarily the depth or complexity of each individual law, but we by current counts, we have about 20 states in the US, 20 of our 50 states that have adopted what are being called a sort of more comprehensive consumer data privacy legislation. And so we've got these all over this. The first one was California with the CCPA. There's been several attempts at the federal level, the federal Congress, to enact broad data privacy law in the US over the past few years. And we've had some legislation that actually some people thought actually had some promise in terms of going someplace, but there's been a number of reasons, including the potential sort of complications between federal law overriding protections in California law. For example, so a couple of years ago, the California delegation to the Congress essentially stopped the federal law from moving forward because the federal law would have preempted state law, and California felt like their law provided additional protections they didn't want to lose. And so they pushed back. And so, but we've seen now a proliferation of laws around the country with 20 states now adopting something of a broad consumer privacy law.
Okay, and so when you look at them, are there lots of, let's say, meaningful or significant divergences between US states' data privacy laws, would you say?
That's a good question. I will have to preface this that I'm familiar with several, but I'm not an expert on all 20. But from what I've seen and from the research I've been doing, the biggest differences are really between California and most of the subsequent approaches. And so in a paper that Nadya and I wrote and published recently, we referred to many of these others as sort of like the Virginia model, which actually came up through the language for that statute that was adopted in Virginia, sort of the next one after California. Has really been copied quite a bit by other states around the country. But there are various ways in which they all differ. And so one of the differences here is sort of when do they apply, right? So rather than being sort of broadly applicable in the way that like the GDPR might be, most of these laws are fairly closely tied to the consumer protection space. And there is a tiered approach to sort of which entities actually accrue obligations. And so the entities that accrue obligations under these laws vary. Some states like California and Utah, there's a specific number that they have to have an annual gross revenue over $25 million, for example, and then they have to meet a couple of other tests, and those typically have to do with a particular number of consumers that the controller might control or process data, say in California, at least are more than 100,000 consumers or consumer households. And often additional prong that might be alternative is, well, or they have to produce or more than X percent, in California's case, more than 50% of the controller's business the revenue should come through data processing. And so that varies quite a bit among the states. They also vary in the way they define some terms, the sorts of exemptions that they provide, and the way in which they define things like selling and sharing and what those things are. Where California has defined sharing in a particular way, where most of the other states, the Virginia model statutes, as we've called them, actually don't define sharing and sort of just look at selling as for example. So again, I think the biggest difference is between California and the rest, which all seem to be fairly homogenous at this point.
But why is it important to know what's the concept of sharing and selling mean?
So it's important to think about the definitions of these things because, in particular, one of the things that's sort of new to the U.S. With the adoption of these types of laws are consumer rights. So, and some of them are similar to the sorts of rights that a data subject has under the GDPR, right? The right to rectify information, to have information removed, or, for example, in the context of sensitive information, many of these states allow users to opt out, essentially to put give an opt-out signal or tell a processor or a controller directly that they want to opt out of future sale, for example, of their sensitive data. And so in those cases, those definitions become important because it defines exactly sort of what subject, what those, sort of the scope of what those rights cover, essentially.
Okay, and when we say sharing and selling, are the definitions intuitive? What's comprised within the concepts? Like if we think about advertising practices, for example?
Yeah, so I mean, for example, California is the one that I'm most familiar with. It actually makes a distinction between sharing and selling. And the interesting thing there is that the basic definition is the same. So in California, to sell means, quote, selling, renting, releasing, disclosing, disseminating, making available, transferring, or otherwise communicating by various means a consumer's personal information by the business, essentially sort of our version of a controller in this statute here, to a third party for monetary or other valuable consideration. So it's essentially doing mostly anything in sort of any form of transfer, dissemination of personal data to some third party, where sharing is exactly the same thing, but under California law, when it's done for the purpose, it's given to the third party for the purpose of enabling cross-context behavioral advertising. And so that's really the biggest distinction there, which is an interesting one when you think that's not sort of a common sense. It's not really, to me, a commonsensical difference between sharing and selling is whether or not it relates to targeted or cross-context advertising, but rather it seems that there's something else there. But most of the other states haven't defined sharing, although several of them actually do use the word share quite a bit in some of the language, but they've removed and don't have a definition for the term, which also complicates things.
Okay, thank you for that. Before we actually had an extensive network of state laws, we had the FTC, of course, trying to tame the space. And the FTC was producing some guidance, and in particular in relation to the identification. And so there was already some building blocks there upon which, of course, the state laws have been building further. There was in particular a 2012 report where we have a standard for the identification. Looking at that and then what the state laws have been doing, do you think there is a homogeneity, uniformity in the approach to the concept?
Yeah, I mean, I think the FTC has been doing good and important work over the years. They've been sort of our primary privacy regulator in many ways prior to the sort of the California's state agency coming online several years ago and actually doing something meaningful in the U.S. And the FTC is largely, I mean, some of this guidance has largely been, it hasn't had the force of law, so it differs in that sense from these data privacy statutes. It's often been sort of best practices. But even when they do have power to initiate investigations of the violation of the FTC's, the laws of the FTC has jurisdiction over, it's mostly around consumer confusion, sort of misleading consumers, not stating something clearly on a privacy policy and then doing something contrary to what your stated policies say. And so it's more, again, it's still within the consumer protection space, but it's a bit more limited. We do see several of these laws that adopt similar provisions that look at these issues of consumer misleading consumers and so forth. So they do include some of those provisions. So there is some duplication there. But I think the rights, well, the status is law, the state law from these statutes is an important difference there. And the number of sort of consumer privacy or data subject rights, they're not really framed that way in most of these laws, but those are new, right? And so those are something that's that even if their scope is not as encompassing as you might think, if you think about this from the GDRs, the way the GDPR has been functioning and framed. But those are new, and I think they are important, even if they're not particularly strong in most cases.
But in relation to the identification concept, do you see convergences of approaches? In particular, also if you look at the federal level, what we have with HIPAA, for example, in the healthcare space.
Yeah, you do. And to be honest, I think that a lot of these statutes, I mean, a lot of these legislatures in these various states have really been just sort of copying and pasting a lot of the language from some of that have existed elsewhere. And I saw this. I was part of when the Oregon adopted a law several years ago, went into force last summer in 2024, a broad consumer data privacy law, and I was part of a broad coalition of folks who were giving input to the state attorney general as they were crafting the initial draft of that law. And at the very beginning, sorry, a very short anecdote, but at the very beginning of that process, the state attorney general, prior attorney general, said, "This is Oregon. Let's do things differently. We don't have to do things just like there's been done in California or Virginia or Colorado, Utah, those sorts of things, those places." But by the end of the process, the law looked very much like the law in Virginia, the law in Colorado, the law in Utah, the law in Connecticut, the others that existed at the time, largely because there were a lot of corporate interests. There were a lot of attorneys representing groups of tech companies and others sort of at the table. And they were very concerned about making, if we're going to have 20 to 50 laws around the US, we want some uniformity, right? Because otherwise it'd make it very difficult to do business. So on one level, I understand that, but on the other, it's sort of I did see a real process of the corporate capture of sort of what the scope of these laws, and Oregon did not do anything sort of really outstanding or unique in that respect, and many of the provisions are almost copied and pasted from these other state laws, and we see that a lot, right? So I think most of these 20 laws that exist around the country are really, in many respects, sort of slightly tweaked carbon copies of each other, and so the language around de-identification and all of that as well has also been copied quite a bit.
Okay, and thinking about AI and AI training and deployment, I mean, do you think they confine in any way the practices that are now happening in many places?
Yeah, I think I think these data privacy laws do capture some of what's going on, but I think it's also important to remember that they are designed as consumer data privacy laws, and so they only regulate the control and processing of personal data within the consumer, right, the business to consumer or consumer business relationship, right? And so processing and other activities or other harms that fall outside of that are really not captured by these laws, right? They're really not comprehensive in the sense that the term comprehensive data privacy law has been thrown around a lot in the US. They are very much consumer protection laws, and the scope is sort of limited to that space very clearly. So I think there's a lot of the harms of the artificial intelligence that falls outside that space, right, that these laws just don't capture. And beyond that, we also see definitions in many of these state laws that are narrower, I would think, certainly than GDPR. I think there's reasons to think that the definition in California of personal information is could be read even as broad as the GDPR, if not more broadly, even perhaps. But most of these are much more narrow definitions of what personal data is. And again, because of the consumer protection focus here, there's a limit on the sorts of entities or organizations, businesses, right, that acquire obligations under these laws. And so that would apply, right, to the entities that are engaging in AI development and deployment and so forth as well. So I think the laws may do something, right, when they just within the consumer data privacy space, but they lack the ability to really say much and do much about the problems in general, because I think AI is really sort of reaching out into all sectors of the economy and sort of social life. So.
Okay, so despite the narrowness of many of these laws, you would agree that the definition of personal data that is in CCPA or CPI is quite broad, at least on paper.
Yeah, on paper it is, and we've had some constructions of that by the we've got the California Consumer essentially the DPA in California now. We've also had a little bit of time with the law, but I think we're still constructing sort of what that looks like. And I think, but on paper, I think that the California law in particular can be read very broadly, but it's not the case for all of these, which some of them are much narrower.
Okay, thank you so much, Bryce, for this initial description of what we have over there. Let me now turn to Karen and try to discover what is now in the Data Use and Access Act, which delivered the first changes to the UK GDPR. What can you tell us, Karen, about what's in there? What's good in that package, and maybe what's less good in that package as well?
Okay, so I think I'll start by saying that this is the culmination of reform efforts following our exit from the European Union. So for those of you who remember, when the UK decided to leave the European Union, it was determined to try and abandon the GDPR on the basis that reform would make the UK a more competitive and innovative landscape. And so we've had a series of legislative proposals that have made their way partially through Parliament, only to be dropped for various different reasons. The bill that did make its way through and eventually become law is the Data Use and Access Act of 2025. It was enacted, received royal assent on the 19th of June 2025, and it is in the process of being implemented incrementally. So I said initially the plan was to identify opportunities for innovation and to do different and to be radically and drastically more competitive than the EU. But what actually happened was every time the government consulted, they sought advice from the business community, they sought advice from academics and so on, and they eventually accepted that maybe they had to scale back on some of the more radical proposals. So three things happened really. The political landscape evolved, and so regulatory divergence became less important as the political heat came out of the Brexit departure from the EU. So the idea of leaving the EU behind became less of a political football or a contested idea. The second thing was economic reality started to bite. And economic reality meant that we needed to prioritize renewal of the, first of all, secure an adequacy decision from the EU, which was a bit of a shock to people in the UK, the fact that we have become a third country and would have to formally have our laws assessed. There was a bit of concern if we mightn't actually get an adequacy decision because of our surveillance laws. We did in the end secure an adequacy decision, but of course it was subject to a 4-year renewal. So that has meant that there has been a slow recognition that divergence from the European standard could potentially jeopardize a renewal of an adequacy decision. And every time they consulted with businesses, the businesses, particularly multinationals, said they would prefer regulatory stability and EU alignment over extensive reform because of the size of the UK market, because of the fact that the supposed competition and innovation opportunities may not actually exist or be worth exploiting in a smaller market such as the UK. So what you saw happening was the Brussels effect, where there was a move towards the higher standard or maintaining the higher EU standard rather than trying to carve out opportunities for divergence. So that was the kind of the background that we were operating against, but I did consult on various different proposals, and so I should probably tell you broadly what's in the Data Use and Access Act. So broadly speaking, there's a lot of small tinkering, minor revisions to existing laws. There are a few proposals that are, or changes that are actually potentially interesting. So from my perspective, potentially the most interesting proposal is, or the most interesting change, I should say, is the one regarding automated decision making. So we are now in a position where solely automated decisions, that is, where there's no meaningful human involvement in the decision, if it's an automated decision with no meaningful human involvement, and it does not involve the processing of special category data, then it is no longer prohibited, provided there are certain safeguards in place. Then we have to ask, what are the safeguards? And the safeguards are that it must include the ability for the data subject to make representations, to contest the decision, and to require human intervention. What's interesting about this change in the law is that it actually reflects what was the previous position in the UK prior to the adoption of the GDPR, when the UK was part of the European Union. So what we see is the UK returning to its previous position. So it is going to be welcomed by businesses and organisations, because the existing prohibition on automated decision making was considered problematic, and it has been particularly stifling for organisations, because as they increase the amount of automation in their processes and start to adopt AI. I should say that for special category data, automated decisions still require either explicit consent or the authorization under the substantial public interest grounds that are set out in Schedule 1 of the Data Protection Act 2018. That the automated decision making is probably the most interesting decision. There's one that is in theory interesting, but I think it may remain hypothetical, and I'll explain why. So Schedule 6, I think it is, of the legislation grants the Secretary of State the power to add new categories of special category data. And so in theory, the Secretary of State can decide if we're going to add to the list of special category data. And in the explanatory notes, it says that this could include emerging new categories such as neurodata or children's personal data. If that happens, it would be interesting, because it would leave us with a different set of special category data than the EU. I wonder why we would do that, or if you'd asked me last week, I would have said, why would you do this? Because if we diverge from the core concept in the GDPR, then we're at risk of jeopardizing renewal of an adequacy decision in due course. But of course, with the omnibus being leaked and the changes being made in that, there's a potential to revisit this, something we'll probably come back to when Nadya speaks. So that's the one that may be of more interest going forward. I should say we've made no changes to the category. This is just a hypothetical conversation. We're giving the Secretary of State the power to do so, but as of yet, the Secretary of State has not chosen to add new categories of special data. As for the rest of the legislation, it's minor tinkering around the edges. So for example, we have a new category of recognized legitimate interests, but really the recognized legitimate interests that are now in Article 6.1 of the legislation are just the codification of what was a previous practice. So we've just taken what we previously did and put it into the legislation. It means that what was common practice is now formally law, but not really a change in terms of how we go about practicing in this area of law. The only other thing that's probably worth a mention is that when it comes to amendment of PECR, the penalty has increased there from £500,000 to 17.5 million, or 4% of the global turnover of an entity. So it's bringing it into alignment with the GDPR penalty.
So e-privacy, when you say PECR, just to...
Yes, sorry, PECR is I've forgotten the name, but it's the UK regulation that implements the e-privacy directive in the UK. And so for a while, there was a concern that the PECR fine was too low and that it wasn't in alignment with the GDPR standards. So we've now raised that, and that should encourage companies and organizations engaged in marketing activities and using cookies and so on to comply with that standard. So if you're asking me for my honest assessment, when we said we were leaving the EU, we were determined to do different, to be bold, to be radical, to be innovative. Where we've ended up is we are trying to make compliance marginally easier for organizations We're trying to reduce some documentation burdens. We're trying to leave some scope for flexibility. But in the back of our minds is the need to continue to maintain some level of alignment with the EU in order to ensure renewal of the adequacy decisions that we have in due course. So automated decision making is probably the one substantive processing change that could be of significance, but most of the rest of the changes just formalize existing practices. So not so sure that it was completely innovative, but these things happen over time.
And just reassure me, there is no new definition of personal data?
No, not that I've seen. We have not attempted to change the definition of personal data.
Special category data, as you said, might be extended, not reduced. Okay, and PECA fines, as you said. How does this, if we think about the AI context, are these there for these changes meaningful?
Time will tell. So I should say that there is one interesting paragraph in the heading of the legislation. We have positioned the regulator, the Information Commissioner's Office, as having a duty to consider innovation and competition. So their job is really supposedly to facilitate innovation and competition, and they're trying to do that in a way that also respects data protection principles and ensures that we maintain our data protection standards. Back to your question, could you remind me, Sophie? What was the question?
Good question. What was that? I was asking. I was looking at my next question. I wanted to ask you a question on data transfer. I was wondering whether the changes were meaningful for governing AI practices.
For governing AI practices, we are waiting and seeing in line with what's happening in the EU, what we should do in relation to AI practices. So you'll see that we have been looking at the definition of special category data. So I'm just trying to find my notes that I've made on it. So special category data, it still exists in the law. We have not yet attempted to change it, but we are paying attention to what is happening in the EU and in relation to the Data Act Omnibus leak that has been made, to see if we need to amend any of our legislation to reflect that, because there's a risk at the moment that we're going to have different approaches. So, for example, under the Data Use and Access Act, there is no liberalization of the concept of special category data in relation to AI. So automatic decision making in AI using special category data remains under strict rules under the UK law as it currently is, but we're looking at the EU Digital Omnibus Act, and it's saying that there could be a new Article 9 derogation for AI training with strong safeguards and security and the removal of anonymization rules. So if that happens, we could have a divergence between the EU and the UK, with the EU going further in enabling sensitive data AI. So I think it's a case of what's the space when it comes to special category data and AI.
Okay, so no new legal basis for AI?
Not yet, not yet.
Okay. And nothing specific on legitimate interest on that part? Not yet. Okay. There is one thing that is interesting is in relation to data transfer, because as regards to data transfer, we don't have anything in the post-omnibus, although the redefinition of personal data might have implications there. What is your reading of what's in there on data transfer, and whether will the tweaks impact practice? So in relation to data transfers, the UK legislation now includes its own test of adequacy. So under the EU law, the test is whether a third country provides an essentially equivalent level of protection. The UK decided that it couldn't possibly accept that wording. So instead, it chose a separate wording, which is that the third country provides a not materially lower standard of data protection.
What exactly the differences will amount to in practice, I can't tell you. But I suspect that this could be more of a semantic difference than a real difference, because not materially lower and essentially equivalent. Yes, they're different words, but if the UK decides to find a third country adequate when it does have significantly lower standards than the UK or the EU standards, then the UK could end up jeopardizing its own adequacy decision with the EU. So I suspect that this has been put in for political purposes, for the purpose of satisfying those who are asking for the UK law to appear different, and to have a different test. But whether or not it will actually lead to the UK adopting more adequacy decisions in respect of third countries, I don't think so. I think that you will see a high degree of uniformity between the countries that the EU finds adequate and the countries that the UK finds adequate.
Okay. Very interesting. In the omnibus, we also have, so it's not only about GDPR, it's also about merging the Data Governance Act into the Data Act. And so you have your own Data Act and we will have our own Data Act. And so I was wondering whether actually the part on facilitating data sharing, smart data access, was actually what was really exciting in the new acts in the UK. What do you think about that?
So the act in the UK, are you asking about the Data Use and Access Act?
Yes.
Yeah, so I should say the Data Use and Access Act is interesting in terms of what it actually focuses on, other than what we would expect it to. So we would expect it to focus on changing provisions in the UK GDPR. But in fact, possibly the more interesting parts of this have nothing to do with the GDPR per se. What they're really doing is trying to promote innovation and openness in parts of the economy. So you'll be familiar that in the EU, we had the Open Banking Initiative for many years, and that was to encourage people to port their data from one company to another. We're trying to build on that in the UK by opening up various parts of the economy and saying that it should be possible for data to be transferred between, for example, the energy sectors, the companies within the energy sector, to try and promote growth and innovation in that. And there's another initiative that we have in relation to the energy infrastructure in the UK, where what we're trying to do is actually map. So I should say, when I was talking about the Open Data Initiative, I'm talking about smart data schemes. So what these sector state and the Treasury have done is to try and designate data holders by sector. So energy companies, telecoms providers, financial services, and those designated data holders are going to be required to provide access to customer and business data to either the customers themselves or to authorized third parties. So we're hoping that by opening up these data sets and allowing people to transfer their data, we will replicate the open banking model where people move their customer accounts from one entity to another, and that fosters greater competition and hopefully greater consumer welfare benefits.
And how would you say that overlaps with data generated by IoT devices?
So, well, in terms of what we're trying to do, we're not trying to relax data protection rules. What we're trying to do instead is create an infrastructure for data portability with strong security and authorization requirements. So it should be about enabling data flows while maintaining the safeguards that we need in place. So that's really where the innovation is going to be, is not in loosening the restrictions, but in creating frameworks that make the valuable data flows move safely. So it's about the facilitation of data transfers rather than a loosening of the data protection standards.
Okay, but I mean, these laws, these schemes are not really defined in relation to data generated by connected products, or
not that I've seen. No, I mean,
Okay.
it's all quite high level in terms of what they're talking about. I should say they've thrown in one other random thing into this legislation, which is NUAR, which is the National Underground Asset Register. So what we're doing in the National Underground Asset Register is trying to create a digital map of all underground pipes and cables in England, Wales, and Northern Ireland. So when I say underground pipes and cables, they're to do with infrastructure. They're things like gas pipes, water pipes, electricity cables, and the telecoms infrastructure. So anything that could be buried underground. Previously, this map was voluntary, and because it was voluntary, the mapping wasn't necessarily up to date or accurate, and this led to lots of chaos where people are digging up cables and bringing down the internet or causing chaos with the infrastructure. So what we're trying to do is have a better mapping system, and why we're trying to have a better mapping system is A, for worker safety, so they don't dig up the wrong things, but B, also to plan our growth model, whether it's housing, whether it's the economy, whether it's rail lines, whether it's new roads. So we're trying to use data in an innovative way by developing a map of the critical infrastructure. And there's also the protection from bad actors from a third country. So we're trying to figure out how to protect our digital infrastructure.
And I suppose essentially also facilitating reuse of that data.
Yes.
Thank you. One last question, because so there is no new test for personal data, there is no new test for anonymization, but the ICO has been working hard over the past few years and produced some new guidance or revised guidance. Is building essentially on what had been done in 2012, I think. So what's your take on what's in there, quickly?
Yeah, so the ICO has published updated guidance on anonymization and pseudonymization. The strengths of it are that it's trying to use the full spectrum of identifiability framework. So we're trying not to classify data in a binary, personal, or anonymous way. Instead, we're saying it's a spectrum of identifiability. We're trying to use a reasonably likely standard. So the idea is that we focus on the practical risk rather than the theoretical risk. That should make data more usable. We're taking a practical approach, and we're focusing on in whose hands. So basically, in alignment with the SRB and EDPS decision, we're looking at in whose hands is the data. So it could be personal data in the hands of one organization, but anonymous data in the hands of another. And if we take that approach, it should allow for data to be used in a wider variety of circumstances, because it will be considered anonymous in some parties' hands, and that will take them outside the scope of the GDPR. But there are still some contradictory statements in the guidance. So the ICO has taken a more restrictive approach when pseudonymized information is shared with joint controllers or processors, saying that it can't really be anonymous in those hands, even if they lack independent means of identification. So this is going to create a bit of uncertainty for joint controllers or processors, and it introduces an identifiability risk assessment, where requirements to organizations are supposed to conduct this and document it alongside their transfer impact assessments, their DPIA, their AI impact assessments, and so on. So there's a risk that what we're doing is we're going to have a lot of onerous obligations for smaller organizations, and this could lead to assessment fatigue and documentation burden. So they have to do so many tests. So the ICO explicitly acknowledges that for large, complex data sets, organizations should seek specialist advice. The guidance says do that, but it doesn't really tell them how to go about conducting those assessments. So again, some of those questions are going to be unanswered for businesses, and that's adding to their compliance burden. So it's a good starting point, but there's more work to be done.
Okay, thank you. But at least, I mean, it's a relative approach. The characterization will depend on who has the data, but at the same time, this is based on the motivated intruder test. So that means that the entity needs to anticipate unauthorized access, which is not exactly emerging from what we have in the formulation that we have in the omnibus. Thank you, Karen. Nadya, the omnibus for the end. So before we touch on the omnibus and we get your reaction live, you've been working with Bryce and you've been comparing approaches before, obviously, the release of the omnibus. But I'd like to get your reaction on what it was working with Bryce and then studying all these US privacy laws, and maybe your thought about complexity somewhere.
So I'll start on a funny note. I think we started collaborating on that paper, comparing the various approaches to what personal data is across the US and in the EU. And I personally sort of was thinking, that's how it is in other jurisdictions. And of course, sort of I was in the position of luxury in the sense that, as we painfully have had the chance to observe, we had a lot to lose. But it was very curious to see how indeed the concept of personal data, they say there is a value in comparative legal research in the sense that essentially all jurisdictions address same kind of problems. And then essentially, even if there are definitional differences, conceptually, we are working sort of within the same mental scaffolding. And so you see clearly there are a lot of similarities in how personal data is defined, in the sense that it is some sort of information, sort of medium, which is linked to people. And then there is a divergence in sort of what that link is. Rereading that paper now, not necessarily even after the omnibus, I see that the US state privacy legislation is sort of a huge test bed for the various definitional alternatives for what personal data could be. So, for instance, one interesting thing that I saw there, I believe that's the Californian Consumer Privacy Act, that defines identifiability, not necessarily linking to an individual, but to a device, which is reasonably linkable to an individual. So, for instance, in the European case law, sometimes the obstacle for finding personal data relating to an identifiable or identified natural person was that the data was linked to a device. And I think the fact that in the US, the approach is broader than that, and the fact that there is no artificial distinction between targeting an individual or targeting a device, which can as well be individual, let's say,
and household.
Device linked to an individual or household, even broader. So that's, as I said, for these reasons, it's extremely interesting for the European data protection scholar to look at what kind of ideas and alternative approaches the state legislators came up with.
Okay, thank you. And have you ever been had a feeling of overwhelming when looking at the privacy laws, trying to create the map?
I do not know how how one would craft data processing in a way that would be compliant across the state legislation, because just the standard of identifiability is so different. I don't know what approaches the law firms advise their clients. I guess abide by the highest standard, but just wrapping your head around the different approaches. And as Bryce said, these approaches are still sort of, you can group them into clusters, but even within clusters, the supervisory authorities still have different sort of practice of application and such. So in terms of simplification, now that is clearly not the case with the state privacy legislation.
Okay, that's interesting. And so what do you think about the Brussels effect?
I think Lillian Edwards, in a different context, in the context of regulation of AI, came up with a brilliant alternative concept of a Mar-a-Lago effect. And I think Brussels effect is clearly making space for Mar-a-Lago effect. And leaving jokes aside, some very nice way to describe the effect of the geoeconomics, let's say, on legal protection.
Okay, but let's look at what's happening in the EU now. I don't know where you want to start, actually. I wanted to ask you, what's your reaction to the simplification agenda before we head to the omnibus? But yeah, go ahead.
Yeah, so I think that it's clear to any data protection scholar that this is not a simplification agenda, at least when it comes to data protection, to the changes in data protection law. This is a drastic change in vision for legal protection of people in an information society. So sort of my understanding of the development and evolution of data protection law was that it made giant steps from sort of its origins in privacy, and then at least in Europe, it has become that law that sort of contains the principles of, to quote Bertiap Koop's, decent treatment of people in information society. And there are other sort of founding fathers of data protection law in Europe that saw the identity of data protection law in being this bundle of rights that protects people in the digital millennium. Let's say Stefano Rodotà, I believe, used these words. And so what we see in the omnibus is a total rollback on that vision. So I do not see any simplification. That might sound a little bit interesting from somebody who wrote the critical paper on the data protection law being the law of everything.
Yes, but that's where I wanted to have you.
Yes, the point that I made there is that. So I am all for that vision of broad protection of people in the information society, but should it be done in one law? And I think, again, so because of that vision, or very optimistic vision of data protection law being this defense against digital arts, anything in the digital context that is wrong, you can find a solution in data protection law. You know, the concept of personal data was developed very broadly, but also the concept of personal data is one single point of failure of that whole protection of that whole regime of decent people, or decent treatment of people in the information society. So I still do not think it's necessarily the best regulatory choice to put all your eggs into one basket. And I think that Omnibus illustrates beautifully why that is not the best choice. But I'm still for broad scope of protection, let's say. And just, well, I'm not sure if I answered your question.
Yeah, you did. You want to say so? I mean, I was going to ask you on the new formulation of the definition, if you had more, I guess, detailed reaction.
Yes. So I think sort of the way I perceived it. So obviously the AI is the, you know, the belle of the ball, or has been for a while now. And some time ago, I believe a year ago, the European Data Protection Board has published its opinion on the data protection aspects of AI. And in that opinion, it became very clear that compliance with data protection law would be very challenging in the context of training AI, because models retain data retain personal data. And so, let's say there are other, and obviously because the AI tools are not developed necessarily by the users of those tools, those users, given the broad definition of personal data and broad approach to identifiability, would be responsible for any data protection violations that would happen on the stage of developing the AI models, including, for instance, the purpose limitation principle. You know, so how would that, considering that the original purpose of processing is the purpose that was stated at the point of collection of data, and then if we basically trace the life cycle of data to the point of using the AI model, which contains that personal data or retains the personal data, so that would be a nightmare. And around that same time, I think the Advocate General published his opinion on the SRB case, which I experienced as a sort of account as a reaction to that reality, that training AI and using AI in the context of very broad approach to data protection law is very challenging, let's say. So what we have now is indeed in following the SRB case, the European data protection law has adopted the so-called relative approach to data protection, which says that to assess the identifiability, we cannot do it in abstract, but we have to take a perspective of the one holding the data. And then the omnibus obviously sort of adopts that same approach. Now, what I can say about that is that, so even obviously the absolute approach to identifiability, looking at any other actor possibly able to identify, is also not the best solution. And I don't want to restate the sort of points of critique that have been made on this, but there are also sort of multiple shades of gray, basically many forms of relative approach that also exist in the national jurisprudence on the member states. So, for instance, one of the approaches was articulated by Jen Koba in her recent paper that she uploaded on SSRN, sort of this contextual approach that you don't look at a broad sort of, so contextual approach is, yeah, you might call it something in the middle between the absolute and extreme version of the relative, where the controller or data holder has to assess a particular context. And then you have to take it, you have to do the assessment from the perspective of that controller, but then sort of have this sort of a reasonable person test. Sort of what could a reasonable controller in this position anticipate in terms of the possibility of identification? So basically, out of all these shades of gray, the Commission has chosen for the most extreme, I would say. And as I said, the data protection law has one point of failure, which is the concept of personal data. And now that system collapsed, that basket with all the eggs has fallen. I'd say obviously the narrower definition of personal data has the domino effect across the GDPR. So just to name one example, how does it affect the concept of a controller and joint controllership? There is an enormous body of case law developed by the Court of Justice on, for instance, joint controllership, where the controller doesn't have to be aware that it processes personal data, and it doesn't have to have access to personal data. So basically, this notion of joint controllership was or has been the way to bring big platforms, for instance, into that accountability scope. So that, I think, well, there might be some tricks maybe to still extend the role of controllership on those sectors without the access to personal data, but that would require, basically, you would have to fight back for the ground that has already been won, but now is to be given up. Another example is the Article 22 prohibition on the automated processing solely based on prohibition of decisions based solely on automated processing of personal data. So that relative approach to identification, it basically breaks the chain of accountability, and which doesn't rhyme very well with the fact that the data processing is a very complex process that has many stages with many different actors, let's say. So suppose somebody outsources the automated processing to a different entity that doesn't have the means to identify. Would that still be a decision based on automated processing of personal data? So just to bring an example, would SHUFA case, let's say, still render the same results, if ruled on the basis of the relative approach to what personal data is? I mean, if you just pseudonymize the data before you send it to a credit rating agency, and then base your, I mean, you could always, perhaps you can sort of work out somehow to still keep a level of protection and somehow, but still these are small steps that have been already made and now they're given up. There are new areas of uncertainty created by that shift towards, by the change in the concept of personal data. So, as I said, there is impact, enormous impact within the system of the GDPR, but also across other legal domains. So, to name an example, DSA, for instance, is, I wouldn't say full of references to the GDPR concepts, but there is an important concept that it does use, this is profiling. So profiling and sensitive data or special categories of personal data. So for instance, indeed with the arrival of the DSA and DMA and the AI Act, the GDPR was not the only sheriff in town. You know, there were other digital laws addressing the digital wrongs. But for instance, the DSA regulates recommender systems, which have been subject to critique for risks to autonomy and what have you. The approach of the DSA to regulation of recommendation systems is transparency, unless the recommender system is based on profiling in the sense of the GDPR, so profiling based on personal data. In that case, the platform has to offer you at least one option which is not based on profiling. So that provision would be meaningless with the relative approach to identifiability, because these digital giants can certainly configure their processing structures in such a way that they are not able to reason or to establish anybody's identity. Now, the guarantees in the European health data spaces, which is such a flagship of the new data law, basically the data in European health data spaces, basically, so data law, emerging data law is really, it should receive more attention for what it is doing. So all the health data, not only held by healthcare institutions, but also, for instance, by lifestyle apps, has to be shared and has to be put into that European health data space. And it will be provided for shared for reuse in a pseudonymized fashion or anonymized fashion. And then the users of those, sort of the secondary users of that health data would have to show the measures they're taking to secure data minimization, I believe, purpose limitation, and what have you. Basically, there is some burden on those users of the health data space. But what does those obligations mean when the data protection guarantees do not apply after pseudonymization? So just another, I'm ranting at the moment. And yet another, so Bryce and I collaborated recently on another paper where we suggested, as an alternative to putting all your protection eggs into one basket, to basically regulate certain risky or undesirable practices, such as surveillance, or let's say surveillance infrastructure. And e-privacy directive was one of those legal instruments that is not dependent on the GDPR in the level of protection that it offers. It does regulate surveillance infrastructure because it has this requirement of placing information on a device or taking information from a device based on consent, with a few exceptions. So that provision applies regardless of whether or not personal data is processed. And what the Commission proposes to do now is to move that provision into the GDPR and make it again conditional on the fact of whether or not personal data is processed. So recommender systems will end up with toothless regulation, I would say. Behavioral advertising or surveillance-based advertising will be largely unregulated. Yeah.
Okay, that's not exactly very optimistic. So we should watch interplay between these regulations to try to understand the impact of that very definition, which seems to be, if we just get it wrong, then everything starts to collapse. Even internally, I mean, beyond transfer, I'd say. Thank you for that. I think I have a question somewhere. Did I see that right? What does this new definition of personal data mean for international data transfer?
It really resolves a lot of problems, because if you anonymize it before transfer, I think one of the there was this sort of elephant in the room of transborder data transfers based sort of in the context of behavioral advertising, in the context of cookies. But basically, the system of the ecosystem of behavioral advertising based sort of using cookies always sort of, or in many cases, just leads to transborder data transfers. Now, problem has been solved. Let's say, in many cases, cookies will not qualify as personal data based on the relative approach or very extreme version of the relative approach to identifiability. So indeed, like sort of the most efficient way to protect the hens in the hen house is just to rule out to redefine the hens and sort of to basically make sure there is less personal data. So well.
Okay, I mean, unless maybe the UTPB managed to convince the Commission that some rigorous guidance could be issued on these concepts, because there is also an Article 41A or something like this in the Omnibus that actually, very interestingly, give the Commission, I think, the power to enact some implementation acts on this concept. So not everything is said already on that, and we need to see. Something else. It could be also coming from that door. And a question on the Q&A. Where Q&A? Let me see if I can fetch the question. Is it accurate to argue that the proposed changes to data protection laws under the EU so-called digital omnibus package go too far, and that the UK is a more innovative and cautious approach to the Data Use and Access Act offers a preferable model for reform? Karen, Nadya, even Bryce.
I'm trying hard not to laugh because living in the UK, where we've had radical proposals, I feel sympathy for my European colleagues who now have to deal with radical proposals and try and persuade politicians to accept basic legal reality and not to undo the foundational concepts. That seems to be the way it's being portrayed at the minute, that the UK is throwing everything up in the air, and the UK has just about calmed down and decided to stick with things. So good luck fighting this battle would be my comment. I think all is not lost yet, but I suspect you have a tougher battle on your hands, because we had the economic reality of wanting to continue to trade with the EU, and that being a strong economic motivator. I can see that you have the opposite problem of wanting to compete with the US and all the lobbying that will come from those interested parties who will be trying to persuade you to stick with watering down of the concept within the EU legislation. Whether you can motivate civil society to help fight back, I don't know. You have my sympathy. It's very odd for the UK to appear to be in a more stable position. But what I would say is these things are always circular. These issues get revisited. So it's a question of trying to impress upon people the importance of these concepts. It really would be a shame if the EU watered down its standards, because they are linked to fundamental human rights. And that is always the beacon that you hold up to the rest of the world, is that the EU really takes its fundamental rights seriously, particularly those relating to privacy and data protection. So I shall stop speaking, but sending you sympathy.
Thank you, Karen. Nadya, do you want to respond to that? Nope. Okay, well, I think we are over the hour actually, and we've covered many different grounds, looking at different jurisdictions. I don't know if my panelists want to add anything to what has been said already. Maybe a final word, a final thought, a final wish. No, everything has been said. Okay, but then we shall see, and we'll end therefore with Karen's words. We have all Karen's sympathy, and we will have the energy to work hard to refine what we have and what we've been given. Thank you so much for joining us this evening. I know this is a very busy week. Lots of things are happening this week, and will continue to happen next week and the week after. Have a very nice evening or afternoon, and see you very soon. Thank you all for staying with us.
Thank you.
Thank you very much. Thank you, Sophie.
Thank you for
Karen and
organizing
Nadya.
it.
Thank you.
Thank you, Sophie and Barbara.
Thank you very much.